Good morning, students. Welcome to AP Online Classes for Intermediate Students. This is Prashasta Kumari. You are watching Civics class. Today you are going to learn from 8th chapter, that is State Judiciary. Okay. So today you are going to learn from 8th chapter, that is State Judiciary. Our topic is also State Judiciary. Okay. So this is Indian Judiciary System or Indian Judiciary System flowchart. Okay, so Indian judiciary is a integrated judiciary and it consists of Supreme Court at the top. So it is the apex court or highest court in our country. Okay, so after Supreme Court, the lower court is State High Court. Okay, so high courts work under Supreme Court. Under high courts, district courts will work. Okay, so district courts are 4 types: district judge court or district civil court, district sessions judge court, or district criminal courts, and third one is family court, and fourth one is SC and SC Act court. So these are the 4 kinds of district courts working in district level. Okay, so district judge court, civil courts work under senior civil judge court, special judicial magistrate court, junior civil judge court, civil and criminal. So these courts are subordinate courts which work under district judge court or district civil courts. Okay. So next one is district sessions judge court or district criminal courts. Okay. Senior district sessions judge court will work under district criminal courts. Okay. So this is the hierarchy or this is the flowchart of Indian judiciary system. Okay. So Indian judiciary is a integrated system. Okay. So let us learn about state judiciary introduction. Okay. So the state judiciary is the third organ of the state government. Okay. The state judiciary is the third organ of the state government. So you all know that government consists of 3 organs. So one is legislature, second one is executive, and third one is judiciary. Okay, so we are having federal type of government. That is why we are having 2 types of government: central government, state government. Okay, so central government consists of 3 organs and also state government also consists 3 organs. So already in your previous classes you have learnt about state legislature, state executive, and today you are going to learn about state judiciary. Okay, so state judiciary is the third organ of the state government and it consists of a high court and a hierarchy of subordinate courts. Okay, so state judiciary consists of high court and also subordinate courts. Okay, the judiciary is the main pillar of the democracy. So we are having democratic type of government. So in democracy, judiciary plays a major role. So it is the main pillar of the democracy. So it acts as the guardian of the rights of the citizen. Okay, so in democracy, many kinds of rights are granted to citizens. So especially fundamental rights are granted in our country. So these rights are protected. These rights are safeguarded by judiciary. Okay, so that is why it can be called as the guardian of the rights of the citizen. It settles disputes, interpret the laws, and protect the spirit of the constitution. Okay, so judiciary will settle disputes and also interpret the laws and protect the spirit of the constitution. So it can also be said as a guardian of the constitution. So judiciary can also be called as a guardian of the constitution. So the interpretation given by the judiciary will be the final for the constitution. Okay. So it settles disputes. So all kinds of disputes will be settled by the judiciary. Okay, so that is about the introduction. And next, coming to the High Court. Okay, so the High Courts are established in India in 1862 at Calcutta, Bombay, and Madras. That means during British rule itself, the system of High Courts was established in 1862. Okay, so at first 3 High Courts were established at a time in 1862 at Calcutta, Bombay, and Madras. Okay. So in 1866, a 4th High Court was also established at Allahabad. Okay, so totally 4 High Courts were established by British government. Okay, the Constitution of India provides a High Court for every state. Okay, our Constitution will provide a high court for every state. So every state will have a separate high court. Articles 214 to 231 in part 6 of Indian Constitution deals with the High Court. So in our Constitution, in part 6 of our Constitution, from Articles 214 to 231, the matters which are regarding to the High Court are explained. Okay, so in our Constitution, High Court was explained from Articles 214 to 231 in part 6. Okay, so at present there are 24 High Courts in India. So we are having 28 states, but we are having only 24 High Courts. That means one High Court can also work for other state also. So Delhi is the only union territory that has a High Court, but the other union territories fall under the jurisdiction of different state high courts. Okay, so Delhi is the only union territory which is having high court. Okay, so other union territories are not having high court, but other union territories will fall under the jurisdiction of different state high court. So this is the system of high court. Okay, so this is our high court. So Andhra Pradesh High Court is here. Next, coming to the composition of High Court. So let us learn about the composition of High Court. So every High Court shall consist of a Chief Justice and other justice. Okay, so every High Court will consist of one Chief Justice and other judges. Okay, so they are appointed by the President of India. Okay, so High Court judges are appointed by the President of India. So Chief Justice and other judges are appointed by the President of India. And ad hoc judges may also be appointed by the President for a period of 2 years. So ad hoc judges means temporary judges. So these temporary judges may be appointed by the President of India based on the workload. Okay, so if the work is more in high courts, then the President of India will appoint more number of ad hoc judges to lessen the work burden. Okay, so they may be appointed for a period of only 2 years. So after 2 years, they will leave their position. Okay, so they will retire from that position. The number of judges varies from 5 in Guwahati High Court to 48 in Allahabad High Court. Okay, so there is no fixed number of judges in High Court. So based on the workload, the President of India will appoint the judges in the High Court. So Guwahati is having very less number of judges. That means only 5 it is having, but whereas Allahabad High Court is having 48 judges in the High Court. Okay. Next, the Constitution does not specify the exact strength of High Court and left it to the discretion of the President. Okay, so the Constitution does not specify the exact strength of High Court. So it is the discretionary power of the President to appoint the number of judges. Okay, so the President will appoint more judges if the cases are more, if the population is more cases will be filed. So there will be more number of High Court judges. Okay, so it is the discretionary power of the President to appoint more number of judges or less number of judges. It is left to the decision of the President. Okay, so he determines the strength of a High Court depending upon its workload. So, okay, President will decide the number based on the workload of the High Court. So that is about the composition of High Court. So next, coming to the appointment of judges. So who will appoint High Court judges? Okay, so let us learn. The Chief Justice of High Court is appointed by the President after consultation with the Chief Justice of India and the Governor of the concerned state. Okay, so the Chief Justice of High Court will be appointed by the President of India and he will consult before appointing the Chief Justice of India. After consultation of Chief Justice of India only, the Chief Justice of High Court will be appointed by the President of India and he will also consult another person. That another person is the Governor of the concerned state. So overall, the Chief Justice of India and the Governor of concerned state will be consulted by the President of India. Okay, so President of India will consult Chief Justice of India and Governor before appointing the Chief Justice of High Court. Okay, so second one is the other judges of High Court are appointed by the President with the consultation of the Chief Justice of the High Court of the concerned state. Okay, so before appointing the other judges, Okay, other judges of the High Court, the President of India will consult the Chief Justice of the High Court of the concerned state. Okay, so Chief Justice of High Court of the concerned state will be consulted by the President of India before appointing the judges of other judges of High Court. Okay, so in case of a common High Court for two or more states, the governor of concerned states are consulted by the President. Okay, so High Court will be there for two or more states. Okay, so common High Court will be there, and for that common High Court, the appointment before appointing the judges, the President of India will consult the governor of concerned states. Okay, so and also the Chief Justice of High Court. Okay, in case of a common High Court for two or more states, the governor of the concerned states are consulted by the President and also the Chief Justice of High Court. Okay, so this is regarding appointment of judges. And next, coming to the qualifications of judges. So what qualification should a judge of a High Court should have? Okay, the first qualification is as usual, that is he should be a citizen of India. Okay, so he should be a citizen of India. And second one is he should have a judicial office in the territory of India for at least 10 years. Okay, so he should have 10 years of judicial experience in judicial office in the territory of India. So in India itself, he should have at least 10 years of experience in courts. Okay, he should have been an advocate of a high court or two or more such courts for 10 years of period. So a judge of high court should have an experience of 10 years as an advocate. Okay, so 10 years he should work in any high court or one or more high courts. Okay, so then only he is eligible to be appointed as the judge of the High Court. And next, fourth one is, however, the Constitution has not prescribed a minimum age for appointment as a judge of a High Court. Okay, so the maximum is 62 years. The retirement age of a High Court judge is 62 years, but the minimum age is not mentioned in our Constitution. Okay, so that is about qualifications of judges of High Court. Next, coming to the tenure. Okay, so what is the tenure of High Court judge? So every judge of a High Court, including Chief Justice, holds office until he attains the age of 62 years. Okay, so the superannuation period or age of a High Court judge is 62 years. So after attaining the age of 62 years, the High Court judge will retire. Okay, so the judges, including the Chief Justice, will take oath in the presence of the governor of the concerned state. Okay, so the President of India will appoint the judges of High Court, including the Chief Justice. Okay, so after giving appointment, they will take oath. Okay, so oath of office in the presence of the governor. That means the governor will conduct the oath of office to Chief Justice of High Court and also judges of the High Court. Okay, so he can resign for his office when he desires so by writing to the President. Okay, the judge of the Supreme Court or the Chief Justice of the judge of the High Court or Chief Justice of High Court can resign. Okay, so before the completion of the term, before their service. Okay, so what he should do means he should write a letter to the President of India. Okay, so then only the President of India will accept this resignation. Okay, so will accept or will reject. It depends on the decision of the President, but they should submit resignation letter only to the President because President is the appointing authority. Okay, so that is regarding the tenure of High Court judge. And next, coming to the method of removal. Okay, so what is the method of removal of a High Court judge? Okay, so until now you have learnt about appointment and tenure, and now you are going to learn the method of removal of a High Court judge. So a judge of a High Court can be removed by the President on the grounds of proved misbehavior or incapacity. Okay, so a judge of a High Court can be removed by the President on the grounds of proved misbehavior or incapacity. Okay, so proved misbehavior or incapacity are the reasons or the grounds on which a high court judge can be removed from his post by the president. Okay, so the method of removal of a judge of the high court shall be the same as that of a judge of the Supreme Court. So, how a Supreme Court judge is removed, you have learnt in your previous classes. I will just remind you, the Supreme Court judge will be removed by the resolution passed by the both the houses of the parliament. Okay, so then only the Supreme Court judge or High Court judge will be removed from their post. Okay, so after the approval of resolution by both the houses of the parliament, then the president of India will remove that judge from his post. So either Supreme Court judge or High Court judge. So that is the procedure for the removal of High Court judge and Supreme Court judge. Okay, so that will happen in the parliament houses. Okay, so that is the method of removal of Supreme Court judge or High Court judge. And next, coming to the acting Chief Justice of High Court. Okay, so who will act Chief Justice of High Court? In which situations? What are the conditions for acting Chief Justice of High Court? Let us learn. The President can appoint duly qualified judge of a High Court as an acting Chief Justice of the High Court when the office of Chief Justice of the High Court is vacant. Okay, so when the office of Chief Justice is vacant, then the President of India will appoint a judge to act as Chief Justice of High Court. Okay, so next one is the Chief Justice of the High Court is temporarily absent. So another situation is there where a president will appoint an acting Chief Justice to High Court means if the Chief Justice is temporarily absent. Okay, so if the Chief Justice is temporarily absent or if the Chief Justice post is vacant, then the President of India will appoint one judge as to act Chief Justice of High Court. So another condition is also there. The Chief Justice of the High Court is unable to perform the duties of his office. So if the Chief Justice of High Court is unable to perform his duties, then also the President of India is having power to act one of the judges of the High Court to act as the Chief Justice of High Court. Okay, so it is the authority, it is the power of the President of India to appoint acting Chief Justice to High Court. So he will appoint in three situations. So one is when the Chief Justice of High Court post is vacant and when he is temporarily absent and when he is not able to do his duties perfectly. Okay, so these are the three situations, three conditions where the President of India will appoint an acting Chief Justice to High Court. Okay, so let us learn additional judge of a High Court. Okay, the President can appoint a duly qualified person as additional judge of a High Court for a temporary period not exceeding 2 years. Okay, so additional judge or ad hoc judge will be appointed by the President of India for a period of 2 years. So when he will appoint means there are two situations or there are two conditions. So first one is there is a temporary increase of work in a High Court. So if a High Court is having more number of cases or more workload is there, then the President of India will appoint an additional judge to a High Court. Okay, so if the workload is more, then President of India will appoint more number of judges or additional judges to High Court. So second condition is if there is pending of work on the High Court, the additional judge cannot hold office after attaining the age 62 years. Okay, so second condition is if there is pending of work on the High Court. Okay, so if workload is more or if the work is in pending condition. So these are the two conditions for which the President of India will appoint additional judge to High Courts. Okay, so these additional judges cannot hold office after attaining the age of 62 years. Okay, so they can work to the maximum. Okay, so to the age of maximum 62 years only. So if they are appointed at the age of 61 years, they may not continue their term of office for 2 years. So they have to retire after the attainment of 62 years. That means if they are appointed at the age of 61, they can work only for 1 year. Okay, so the maximum is 62 years for the retirement. Okay, so temporary period is 2 years. So these additional judges or ad hoc judges can work at least for the completion of 2 years, but before the attainment of 62 years. So that is condition. Okay, so next one is acting judge of a high court. Okay, so the president can appoint a duly qualified person as an acting judge of a high court when a judge of that high court is unable to perform the duties of his office due to absence or any other reasons. Okay, so if a judge is absent or if a judge is not able to do his work properly, then acting judge will be appointed by the president of India to the high court. So second condition is the acting judge should hold office until the permanent judge resumes his office. So this acting judge will be there in that position until the permanent judge resumes his office. That means he will act as an in charge. Okay, so the acting judge should hold office until the permanent judge resumes his office. Okay, so if a permanent judge will join in the office, then he has to vacate that place, that acting judge. Okay, so the acting judge cannot hold office after attaining the age of 62 years. So either acting judge or additional judge or ad hoc judge. Okay, so judge of high court. Okay, so they can't do their service after the age of 62 years. So they can do their service until 62 years only. So until the attainment of the age of 62 years only. Okay, so that is about acting judge of a high court. And next coming to the a profile on high court. So these are the names of the high courts and their jurisdiction. Okay, so in our country. Okay, so let us read out them. So first one is Allahabad. Okay, so Allahabad High Court, it is the name of the High Court and its jurisdiction is Uttar Pradesh. And next Andhra Pradesh, its jurisdiction is Andhra Pradesh. And Bombay High Court and its jurisdiction covers Maharashtra, Dadra and Nagar Haveli, Goa and Daman and Diu. Okay, so those are union territories. Okay, Dadar and Nagar Haveli, Daman and Diu are union territories, and Goa and Maharashtra are states. Okay, so these come under the jurisdiction of Bombay High Court. So next one is Kolkata. Okay, so Kolkata High Court. Okay, so Kolkata High Court jurisdiction is West Bengal, Andaman and Nicobar Island. So Andaman and Nicobar Islands are union territories, and they come under the jurisdiction of Kolkata High Court. And next one is Delhi High Court. This is the only union territory which is having High Court. Okay, so next Guwahati High Court. So Guwahati High Court jurisdiction is Assam, Manipur, Nagaland, Tripura, Mizoram and Arunachal Pradesh. Okay, 3, 4, 5, 6 states. Okay, so Guwahati High Court is having jurisdiction of 6 states. And next one is Gujarat. Okay, so Gujarat jurisdiction is Gujarat, and Himachal Pradesh High Court jurisdiction is Himachal Pradesh, and Jammu and Kashmir, and Karnataka, Kerala is having jurisdiction of Kerala and Lakshadweep. Okay, so Lakshadweep is union territory and Kerala is its state. Okay, so Kerala is having Kerala and Lakshadweep under its jurisdiction. And next Madhya Pradesh. So Madhya Pradesh is having jurisdiction, Madhya Pradesh. And next coming to Madras. Okay, so Madras High Court is having jurisdiction of Tamil Nadu and Pondicherry. Okay, so Puducherry or Pondicherry is a union territory and Tamil Nadu is state under Madras High Court. And next Orissa. Okay, so next Odisha, its jurisdiction, and Patna High Court and its jurisdiction is Bihar. Punjab and Haryana High Court, its jurisdiction is Punjab and Haryana. And next Rajasthan High Court, it's how Rajasthan as its jurisdiction. And next Sikkim, Chhattisgarh High Court as Chhattisgarh, and Uttaranchal High Court as jurisdiction Uttaranchal, and Jharkhand High Court is having jurisdiction Jharkhand, and Manipur High Court is having jurisdiction Manipur, and Meghalaya High Court is having jurisdiction as Meghalaya, and Tripura is having Tripura as its jurisdiction. So these are the 24 high courts which are working in our country. Okay. And next, coming to the main topic of High Court, that is powers and functions of High Court. So let us learn the powers and functions of High Court. Okay, so these are the powers and functions of High Court. So I will read out. The first one is original jurisdiction. Second one is appellate jurisdiction. Third one is court of record. Fourth one is judicial review. Fifth one is power of certification. Sixth one is advisory functions. Seventh one is administrative functions, and eighth one is other functions. Okay, so these are the 8 powers and functions of High Court in our country. Okay, so let us learn these powers in detail one by one. Okay, so the first power is original jurisdiction. Okay, the first power of High Court is original jurisdiction. So what under original jurisdiction it will enjoy, let us learn. So every High Court in India has original jurisdiction in regard to matters of marriage, divorce, company laws, contempt of court, revenue cases, etc. Okay, so every High Court under original jurisdiction, it will deal the matters, or it will settle the matters, or it will settle the cases regarding marriage, divorce, company laws, contempt of court, revenue cases, etc. Okay, so under the original jurisdiction. And next, it is empowered to issue writs like habeas corpus, mandamus, prohibition, certiorari, warranto under Article 226 for the enforcement of fundamental rights. Okay, in your previous classes itself, you have learned that Supreme Court can also issue writs to protect fundamental rights under Article 32, and High Court will have that authority under Article 226. Okay, so High Court can also issue writs to protect fundamental rights like habeas corpus, mandamus, prohibition, certiorari, quo warranto. Okay, so it is empowered to settle disputes relating to election of members of parliament and state legislature. Okay, so under original jurisdiction, the High Court is empowered to settle disputes related to or relating to election of members of parliament. Okay, so MP's election related matter disputes, election disputes, and state legislature, that means MLAs or MLCs election disputes can also be settled by the High Court. Okay, so it here civil cases involving property of the value of rupees 20,000 or more. Under the original jurisdiction, the civil cases involving the property of a value of rupees 20,000 can be dealt by High Court. Okay, so that is these are the points regarding original jurisdiction. Okay, and next coming to the second power, that is appellate jurisdiction. Okay, second power is appellate jurisdiction. So every High Court hears appeals of both civil and criminal cases against the judgment of the subordinate courts. Okay, that means district level courts. So from district level courts, the cases will be appealed in the High Court. So both civil and criminal cases. So if the judgment is not satisfied, then they can appeal in the higher court, that is High Court. Okay, so district level courts, High Court is a High Court. And next, in civil cases, appeals can be made from rupees 5 lakhs. Okay, so in civil cases, the appeals which can be appealed in the High Court can be made only from 5 lakhs. So below 5 lakhs, they can't be appealed. And if a subordinate court differs from the decision of an inferior court, a second appeal can be made to the High Court. Okay, so if if the subordinate court gives one kind of judgment, and another court that is higher than its court. Okay, so if the subordinate courts give one kind of judgment, and if the district court gives another kind of judgment, then it is varying. The judgment is varying. So these kind of cases can also be appealed to High Court. Okay, so the High Court, after the judgment of the High Court also, they can approach to Supreme Court. So this is the hierarchy of appeals. Okay, so from lower courts to High Court, and High Court to Supreme Court. And next, in criminal cases, it hears the appeals in which the accused Okay, so in criminal cases, it hears the appeals in which the accused has been sentenced to more than 7 years imprisonment by the sessions judge. Okay, so district district criminal court judge can be called as sessions judge. So if the district court judge, criminal court judge gives punishment of more than 7 years imprisonment, then also those cases can also be appealed in the high court. Okay, so in criminal cases, and next all cases involving capital punishment that can be appealed in high court. Okay, so capital punishment means death sentence. Okay, so all the cases are related to death sentence. So death sentences can be appealed in the high court. Okay. So next, the imposition of the death sentences by the district sessions judge should be approved by the high court. Okay. So district session judge or district criminal court judge is having power to impose death punishment. Okay. So death sentence. So but these death sentences, the death sentences should be approved by the high court. So then only they will be implemented. Okay, so the imposition of the death sentences by the district sessions judge should be approved by the high court. So after the approval of the high court only, they will be put into practice. Okay, so that is regarding appellate jurisdiction. And next, coming to third power, that is a court of record. Okay, so a court of record. The High Court acts as a court of record and records all its decisions and judgments. Okay, so Supreme Court is also having the same kind of power. Okay, so Supreme Court will also record all its judgments, all its decisions to be as a guide to lower courts. So in the same manner, the High Court will also is also having power to record all the decisions and judgments. Okay, so these are the guidelines for the lower courts, subordinate courts. Okay, so they are taken as judicial precedents and cannot be questioned as referred to or produced before any court of law within the state. Okay, so these judicial decisions and judgments cannot be questioned anywhere. Okay, so in any court of law within the state. Okay, so next, under Article 215, the High Court gets the power of the court of record. Okay, so under Article 215, the High Court is having power to record all its decisions and judgments. Okay, so that is about court of record. And next, coming to the fourth power, that is power of judicial review. So in your previous classes itself, while you are learning about Supreme Court, you learnt about judicial review. So what is judicial review? So this judicial review is also the power of High Court. Okay, so the High Court possesses the power of judicial review like the Supreme Court. Okay, so both Supreme Court and High Courts are having judicial review power. So it examines the constitutionality of legislature, enactments, and executive orders of both the central and state government. So that is the definition of judicial review. So according to judicial review power, the Supreme Court or the High Court will examine the constitutionality of legislature, enactments, and executive orders of both the central and state governments. Okay, so they can examine the enactments and orders of both central and state governments. And next, if they are found to be violated of the constitution, they can be declared as illegal, unconstitutional, invalid, null and void, or ultra voids. Okay, so if those enactments or if those executive orders are not according to the constitution, then they can be declared as invalid or unconstitutional or null and void or ultra voids. Okay, so by the High Court and Supreme Courts. And next, the 42nd Amendment Act 1976 curtailed the judicial review power of High Court. So in the 1976, 42nd Amendment was done to our Constitution. So in that amendment, judicial review was curtailed. That means the judicial review was cut to High Court. Okay, so that was deleted from the powers of High Court. But again, in 1977, the 43rd Amendment Act 1977 restored the original position to High Court. So that judicial review was removed from the powers of High Court in the year 1976, but again it was replaced and again it was restored in the year 1977 through 43rd Constitutional Amendment. Okay, so that is about power of judicial review. And next, coming to the power of certification. Okay, so the High Court will certify certain cases which can be appealed before the Supreme Court. So only if High Court certifies, then only those cases will be appealed before the High Court. So all the cases cannot be appealed before High Court. Only the cases which are certified by the High Court only can be appealed in the Supreme Court. And the cases which got the certificate of the High Court can be appealed in the Supreme Court. Okay, so that is regarding power of certification. And next, coming to the advisory functions. So what are the advisory functions of High Court? The High Court is consulted by the state governor in the matters of appointment, posting and promotion of district judges and personnel to judicial services. Okay, so High Court will be consulted, or the Chief Justice of High Court will be consulted by the state governor. So when means whenever the appointment to the district judges is made, and when he is going to give postings and promotions to district judges, then the concerned state governor will ask the opinion, or will ask the advice, or will consult High Court or High Court Chief Justice. Okay, so next, it renders advice to the subordinate courts in the matters of public interest or of legal importance. Okay, so the High Court will also give advices to subordinate courts. Okay, so district level courts and subordinate lower courts. Okay, subordinate courts in the matters of public interest or of legal importance. So these are the advisory functions of High Court. And next, coming to the seventh power, that is administrative functions. Okay, so this is very important function of High Court. So let us learn them. So under Article 227, every High Court has the power of supervision over all courts and tribunals except military courts in its territorial jurisdiction. Okay, so under Article 227, every High Court is having power to supervise the lower courts. So all lower courts. Okay, and also tribunals except military courts. So it cannot supervise, High Court cannot supervise military courts. Okay, and next, it issues general rules and regulations to the subordinate courts. So all the lower courts, all subordinate courts will be given rules and regulations by the High Court. Okay, so High Court will issue rules and regulations to the subordinate courts. And next, it can transfer any case from one court to another court under Article 228. So according to Article 228, the High Court is having power to transfer one case or any case, okay, from one court to or another court. Okay, so it is having that power. And next, it has power to investigate or inquire into the records of any subordinate court. The High Court is having power to investigate or inquire into the records of any subordinate court. So that is its authority, and it appoints its administrative staff and determines their salaries and allowances. Okay, the salaries and allowances of its staff, administrative staff, will be determined by the High Court. Okay, so it is empowered to withdraw any case involving the interpretation of the Constitution. So this High Court is also having power to withdraw any case involving the interpretation of the Constitution. Okay, so interpretation of Constitution is held with only judiciary. Okay, so it can be called as a guardian of the judiciary. So that is why it can withdraw any case involving the interpretation of the Constitution. Okay, so that is about administrative functions. And next, coming to the other functions. So what are the other functions means? The High Court acts as a district court where its headquarters is located. Okay, so if the High Court is located in the district as in the capital city or the headquarters, then it can be it can also act as a district court. Okay, the High Court acts as a district court where its headquarters is located. So every state is having its own capital. Okay, so in that capital or in that headquarters, High Court is located. Okay, so that High Court will act as both High Court and also district court. There will be no special district court in that location or in that headquarters. Okay. And next, the Chief Justice of the High Court acts as the governor on the direction of the president tentatively whenever the vacancy arises in that office. Okay, so if the governor post is vacant, then the Chief Justice of the High Court is also having privilege to be appointed or to act as a governor. Okay, so if only if if the post of governor is vacant. Okay, so under the directions of the president only for temporary period. Okay, tentatively whenever the vacancy arises in that office. And next, the High Court can admit public interest litigation like the Supreme Court of India. Okay, so Supreme Court and also High Courts are having judicial review and also pill power. Okay, so what is pill means you have learnt in your previous class itself. That means these cases are filed not by the victim but by the other persons or other any other voluntary organizations on behalf of that victim. They can file that case in the Supreme Court or High Court. So those cases can be called as public interest litigation cases. Okay, so these are allowed only in High Courts and Supreme Court. Okay, so that is about other functions. Next, coming to the district level judiciary. Okay, so let us learn about district level judiciary. The state judiciary consists of a high court and a hierarchy of subordinate courts, also known as district courts. Okay, so they hear civil and criminal cases. So these subordinate courts can also be called as district courts, and they will hear civil and criminal cases. And Articles 233 to 237 in Part 6 of Indian Constitution deals with the subordinate courts. Okay, so from Article 233 to 237, these subordinate courts were described in our Constitution in Part 6. And next, Article 233 deals with appointment, posting, and promotion of district judges. And next, they are appointed by the governor of the state in consultation with the High Court. Okay, so district level judges are appointed by the governor of the concerned state. And next, after consulting with the High Court Chief Justice. Okay, so the district judge can deal both civil and criminal cases. When he deals civil cases, he is called as district judge. When he deals criminal cases, he is called as sessions judge. Okay, so the same district judge can be called two post. Okay, so he can be called as district judge when he deals civil cases, and he can be called as sessions judge when he deals with criminal cases, and he has supervisory powers over all the subordinate courts. Okay, so that is about district level judiciary. And let us learn the qualifications of district judges. So he should not be already be in the service of the central or the state government. Okay, so next, he should have 7 years of experience as an advocate to be appointed as district court judge, and he should be recommended by the High Court for appointed. So then only he is qualified, he is eligible to be appointed as a district court judge. And next, coming to the civil courts. Okay, the civil courts deals with civil matters like marriage, divorce, inheritance, business, etc. And they are district civil courts, senior civil judge courts, and junior civil judge courts. Okay, so judicial officers of subordinate courts are principal district judge, family court judge, SC and SC Act court judge, senior civil court judge, and junior court judge. And next, coming to the criminal courts. Okay, the sessions court is the highest criminal court in the district. The sessions judge delivers judgment according to Indian Penal Code and Criminal Procedure Code. The district level criminal courts judges are district sessions judge, senior assistant sessions judge, junior civil judge, special judicial magistrate. So that is about civil courts and criminal courts. And coming to the state advocate general. Okay, so every state shall have an advocate general as the highest law officer in the state. So state advocate general is the highest law officer, and he is equal to High Court judge. Okay, so his qualifications are also equal to High Court judge, and he performs similar functions of Attorney General of India at central level. And Okay, so his qualifications are same as qualifications of High Court judge, and his tenure and removal procedures are not mentioned in the Constitution. He holds office during the pleasure of the governor, and he may be removed by the governor at any time. So he will be appointed by the governor and he will be removed by the governor. So he resigns when the government resigns or replaced, and his remuneration is not fixed by the Constitution. Okay, so his remuneration is not fixed by the Constitution. So that is about State Advocate General. Let us learn about his powers and functions. Okay, so powers and functions of State Advocate General. So he advises the government regarding the legal matters which are referred to him by the governor. Okay, so he is a legal advisor to state government, and he performs duties of legal character that are assigned to him by the governor. Okay, so whatever governor assigns, that work will be done by State Advocate General. So he discharges the functions conferred on him by the Constitution, and he appears before any court of law within the state. Okay, so he will also appear in any court of law on behalf of state government, and he has right to speak and to take part as member in the proceedings of the legislative houses, but has no right to vote. Okay, so he can participate in the meetings of legislative assembly and legislative council, but he has no right to vote. And he can also attend any of the standing committee meeting of state legislature. Okay, so these are the powers and functions of State Advocate General, and we have arrived to the last segment of our class, okay, of this session, and this is the assignment which I am going to give you for today's class, and these are the important questions for your examination point of view for your IPA. So all of you take this assignment and all of you write these questions and prepare answers for these questions. You can get answers for all these questions in this class itself. Okay, so I will read out what are the questions I have given to you for today's assignment. Okay, so the first question is explain the powers and functions of the High Court. Okay, so explain the powers and functions of the High Court, and this question will be given for 5 marks. And second one is explain the administrative functions of the High Court, and it is also 5 marks question. And explain the composition of High Court. So this question will be given for either 2 marks or 5 marks. Okay, so next one is fourth one, appointment of High Court judges. Okay, so appointment of High Court judges it is 2 marks question. And qualifications of High Court judges, it is also 2 marks question. And High Court as a court of record, so it is one of the powers of High Court, and it is for 2 marks question. And district courts, okay, so you have to explain district courts, it is also for 2 marks question. And eighth question is discuss the powers and functions of State Advocate General, so it is also given for 5 marks. And write an essay on district level courts, so this is also given for 5 marks. So these are the 9 questions which I have given to you for today's assignment. Okay, so as today's assignment I have given all these questions. Okay, so I hope all of you understood this topic, that is state judiciary. Okay, so I hope you all make or you all prepare notes for all these questions and prepare well for your examinations. Okay, now I am going to conclude this session. Okay, thank you one and all.
Good morning, everybody. How are you? I am very happy to introduce another concept regarding to partnership form of business organization. Partnership, in which very important concept is admission of the partner. Admission of the partner. Today, I would like to focus my concentration on admission of the partner. Admission. Admission of the partner. Admission of the partner. Today, I would like to focus my concentration on admission of the partner. Any existing partnership business is willing to expand and diversification, it is needed to more capital, more managerial skill, etc. etc. In this situation, only option is in front of the business is to admission of the new partner, admission of the new partner, admit new partner or partners, new partner, partner or partners, new partner or partners. When in running partnership business, new partner is admitted for more managerial skill, for more capital or additional capital, for experience benefits and other important items. When new partner is admitted into the partnership firm, called as admission of the new partner into the firm. Partnership Act 1932, Partnership Act 1931, Partnership Act 1932, Section 1. In partnership business, nobody can enter without consent of the rest of the partners. So, with the consent of the rest of the partner, new partner is admitted. Without consent of the rest of the old partners, no partner cannot be enter into the business, partnership business. So, when new partner is admitted, he may acquire two rights. Rights of the new partner, rights of new partner. Number one, the right to share in future profits. Right to share in future profits and losses also. Next, number 2, right to share in assets. Next, number 3, right to participate in the management of fire. Right to participate in management, in business. When new partner is admitted, new partner have the following rights. Number 1, right to share in the future profits and losses, right to share in assets, right to share in participation of the business. These are the new rights goes in favor of the old partner, new partner along with existing partner. So, when new partner is admitted into the firm, agreement among the old partners is terminated and a new agreement came into force. So, in these circumstances, there is a need to make certain adjustments. So, the important adjustments are made at the time of new partner. Important adjustments are to be made at the time of admission of the new partner. Important adjustments is to be made at the time of admission, of the new partner. Admission of new partner. So these are the following very important adjustments is to be made at the time of the admission of the new partner. Number 1 adjustment: calculation of new profit sharing ratio. Calculation of new profit sharing ratio. New profit sharing ratio, calculation of new profit sharing ratio. So it is the first method, it is the first step, it is the first adjustment is to be made at the time of the new partner into the partnership firm. Number 2, revaluation of assets, revaluation accounting, revaluation of assets and liabilities, assets and liabilities. Revaluation of assets and liabilities. Number 3, valuation of goodwill. Valuation of goodwill or goodwill account is to be designed. Next, distribution of accumulated profits. Distribution of accumulated profits. Distribution of accumulated profit or undistributed profits. Undistributed profits. Distribution of undistributed profits or accumulation of accumulated distribution profits. Next, number 5. Partners capital adjustments. Partners capital adjustments. Partners capital adjustments. Number 6. Preparation of new balance sheet. Preparation of new balance sheet. These are the most important adjustments is to be made at the time of admission of the new partner into the firm. Once again, calculation of new profit sharing ratio, valuation of the assets and liabilities, valuation of the goodwill, distribution of undistributed profits like reserve, another undistributed profits. Next, partners capital adjustment is to be made. Finally, preparation of new balance sheet. These are the very important adjustments is to be made at the time of admission of the new partner. Number 1, calculation of new profit sharing ratio. When new partner is admitted into the firm, he may acquire profit sharing ratio from old partners. So, new partner share is completely depending upon the agreement among the new partners and old partners. Generally, new profit sharing ratio, old ratio minus sacrificing ratio. So, any partner is admitted into the firm, certain percentage are saved. Old partners may forgo their share in profits and losses. So, there are certain situations may be arises while calculating the new profit sharing ratio. Situation 1. When new partner ratio is given, ratio is given when new partner ratio is given along with old partners This is the first situation. When new partner is admitted, he may given certain ratio along with old partners. Example or illustration 1. X and Y are partners. X and Y are partners. Their profit sharing ratio, profit and sharing ratio, profit sharing ratio is 3:2. Their profit sharing ratio is 3:2. They admitted Jed as a new partner for 1/5 share. Calculate new profit sharing ratio. Calculate new profit sharing ratio. New profit sharing ratio. This is illustration 1, in which X and Y are partners. Their profit sharing ratio is 3:2. They admitted Z as a new partner for 1/5 share. Calculate new profit sharing ratio. So, situation number 1, when new partner ratio is given along with old partners. Here, old partner ratio is 3:2 and new partner ratio also was given 1/5 share. So now we can calculate new profit sharing ratio. Calculation of new profit sharing ratio. Calculation of new profit sharing ratio. Calculation of new profit sharing ratio. We can assume total sales is 1. Total share 1. We can assume 1. Total share we can assume 1. Share to be given to Z. Share to be given to Z 1/5. Remaining share or ratio 1 minus 1/5 is equal to 4/5, in which old partners can be distributed according to their profit sharing ratio. So now X new ratio is equal to X new ratio is equal to X new ratio is equal to remaining ratio 4/5 multiplied by X old ratio 3/5. That is 12/25. Then Y new ratio is remaining ratio 4/5 minus Y old ratio 2/5. That is 2/5 by 5 into 4 by 5 multiplied by 2 by 5. 4 by 5 multiplied by 2 by 5. 8 by 25. 8 by 25. 8 by 25. XY. Z ratio. Z ratio 1 by 5. Therefore, new profit sharing ratio is equal to new profit sharing ratio of X, Y and Z is equal to 12 by 25 is to 8 by 25, 12 by 25 is to 8 by 25 is to 1 by 5. 1 by 5. That is 8 is to 12 is to 8 is to 5. 12 is to 8 is to 5. This is new profit sharing ratio of X, Y and Z. So in this illustration, we can assume total share to be given to Z 1 by 5. Remaining share 1 minus 1 by 5 is equal to 4 by 5. X new ratio 4 by 5. Remaining share 4 by 5 multiplied by old ratio 3 by 5 is equal to 12 by 25. Next, Y new ratio. Remaining share 4 by 5 minus Y old ratio 2 by 5 is equal to 8 by 25. Z ratio 1 by 50. So therefore, new profit sharing ratio of X, Y, Z is equal to 12 by 25, 8 by 25, 1 by 25. We can simplify that 12 is to 8 is to 5. This is the new profit sharing ratio. New profit sharing ratio. So we can assume we can work out one more problem. When new partner ratio is admitted, one more problem. Now, next we can assume example 2, illustration 2. Ramesh and Mahesh are partners. Ramesh and Mahesh are partners. Ramesh and Mahesh are partners. Their profit in sharing with profits and losses 3 by 2, 3 is to 2. They admitted Suresh as a new partner. For 1 by 4th share. 1 by 4th share. Calculate new profit sharing ratio. New profit sharing ratio. In this exercise, Ramesh and Mahesh are partners. Their profit sharing ratio 3 is to 2. They admitted Suresh as a new partner for 1 by 4th share. Calculate new profit sharing ratio. So in this exercise, we can interpret it in proper way. Calculation of new profit sharing ratio. We can assume total share is 1. We can assume total share is 1. Suresh share to be given to Suresh. Share share to be given to Suresh. Share to be given to Suresh 1/4 share. 1/4 share. Remaining share. Remaining share 1 minus 1/4 is equal to 3/4 share. 3/4 share. So here Ramesh new share. Ramesh new ratio is equal to remaining share 3/4 multiplied by Ramesh old share, that is 3/5. 3/5. 9/20. 9/20 is Ramesh new share. Then Mahesh new share. Mahesh new ratio or share. Remaining share 3/4 multiplied by Mahesh old share 2/5. 2/5. That is 5/20. 5/20. Next, Suresh share 1/4. 1/4. Therefore, new profit sharing ratio of new profit sharing ratio of x, y and z is equal to x, y and z is equal to 9/20 is to 5/20 is to 1/4. 1/4. We can simplify 29 is to 5 is to 5. 9 is to 5 is to 5. This is new profit sharing ratio of Ramesh, Mahesh and Suresh. This is the first situation. So total share we can assume 1 share will be given to Suresh 1/4. Remaining share 1 minus 1/4 is equal to 3/4. Ramesh new share. Remaining share 3/4 multiplied by 3/5 is equal to 9/20. Mahesh new ratio. Remaining ratio 3/4 minus multiplied by 2/5. 5/20. So 9/20 is to 5/20 is to 1/5 is equal 9 is to 5 is to 5. This is new profit sharing ratio. This is situation 1. Next situation 2. Situation 2. Situation 2. When new partner get his share equally from old partners from old partners. This is second situation. Situation number 1, when new partner ratio is given along with old partners. Here, when new partner get his share equally from old partners. Exercise 3, illustration 3. For example, A and B are partners. A and B are partners. Their profit sharing ratio is 3:2. 3:2. Therefore, admitted C as a new partner. They admitted C as a new partner for 1 by 5th share. Which C acquired equally from A and B. Calculate new profit sharing ratio. Calculate new profit sharing ratio of new profit sharing ratio of A, B and C. A, B and C. This is the second condition in which A, B are partners. Their profit sharing ratio 3:2. They admitted C as a new partner for the following terms and new partner for 1/5 share, for which she acquire equally from A and B. In this share, we can calculate new profit sharing ratio. So share to be given to C. C is 1/5 share. Share to be given to C is 1 by 5th share. 1 by 5th share. So that is equally get from A and B, which equally get from A and B. So now 1 by 5 multiplied by 1 by 2 is equal to 1 by 10. So C acquired 1 by 10 from A and 1 by 10 from B. So here A forgo 1 by 10 from his old ratio and B forgo 1 by 10 from his old ratio. So share to be given to C 1 by 5th. Share to be given to 1 by 5th, and which is equally get from A and B. So now old ratio is equal to old ratio is 3:2. Old ratio is 3:2. Now A new ratio is old ratio 3 by 5 minus sacrificing ratio 1 by 10. That is 5 by 10. 5 by 10 is A new ratio. Then B new ratio is B old ratio 2 by 5 minus sacrificing 1 by 10. 1 by 10 is equal 3 by 10. 3 by 10. 3 by 10. So therefore, new profit sharing ratio. New profit sharing ratio 2 by 5. New profit sharing ratio. New profit sharing ratio of A, B and C is 5 by 10 is to 3 by 10 is to 1 by 10. 1 by 10. Sorry, 1 by 5. 5 by 10 is to 3 by 10 is to 1 by 5. 1 by 5. Therefore, 5 is to 3 is to 2. This is a new profit sharing ratio of A, B and C. A, B and C. So this is a second situation. When new partner get his share equally from all partners. Example, A and B are partners. Their profit sharing ratio is 3 is to 2. They admitted C as a new partner for 1/5 share, for which C acquired equally from A and B. Calculate new profit sharing ratio of A, B and C. So once again, share to be given to C 1 by 50 share, which equally get from A and B. So 1 by 5 multiplied by 1 by 2 is equal to 1 by 10. So this is a 1 by 10 share acquiring from A, 1 by 10 share acquiring from B by new partner C. So what profit sharing ratio? 3 is to 2. 3 is to 2. A new ratio 1 by 10. That is 5 by 10. Similarly, B new ratio is equal to 2 by 5 minus 1 by 10. 1 by 10 is equal to 3 by 10. 3 by 10. New profit sharing ratio is equal to ratio of A, B and C. 5 by 10 is to 3 by 10 is to 1 by 5 is equal to 5 is to 3 is to 2. This is the second situation. So we can do one more problem related to second situation. We can do one more problem related to second situation. Raju and Rao are partners. Their profit sharing ratio, profit sharing ratio is 6 is to 4. 6 is to 4. Their profit sharing ratio is 6 is to 4. So they admitted Ram as a new partner. Ram as a new partner. Partner for 2 by 10th share. 2 by 10th share, which acquired which Ram acquired equally from Raju and Rao. Raju calculate new profit sharing ratio. Calculate new profit sharing ratio. Calculate new profit sharing ratio. New profit sharing ratio. So here in this problem, share to be given wrong. Share to be given to wrong 2 by 10, which Ram acquired equally from Raju and Rao. So Ram acquired equally. Ram acquired equally from Raju and Rao. That is 2 by 10 into 1 by 2. 2 by 10 into 1 by 2 which is equal 2 by 20. 2 by 20. So 2 by 20 say, that is, you can simplify 1 by 10 say. So 1 by 10 or 2 by 20 say, forgo in favor of Ram by Raju. Similarly, 2 by 10 or 2 by 20 or 1 by 10 share forgo in favor of Ram by Rao. So that's why now calculation of new profit sharing, Ram acquired equally from Raju and Rao, that is 2 by 10 multiplied by 1 by 10 equals 2 by 20, 2 by 20 or 2 by 20 or 1 by 10. So now Raju new ratio is equal. Old ratio is 6:4. 6 by 10, 4 by 10. So now Raju new ratio is old ratio 6 by 10 minus sacrificing ratio 2 by 20. That is 18 by 20. That is 18 by 20. Next, Rao new ratio. Is equal old ratio 4 by 10 multiply old ratio 4 by 10 minus sacrificing ratio 2 by 20 or 1 by 10. That is 8 minus 2 is equal 6 by 20. 6 by 20. So new profit sharing ratio of therefore new profit sharing ratio of Raju, Rao and Ram. Raju, Rao and Ram. Raju, Rao and Ram is equal to 8 by 20. 8 by 20 is to 6 by 20 is to 8 by 20, 6 by 20 is to 2 by 10. 2 by 10. This is new profit sharing. We can simplify 8 is to 6 is to 4. 8:6:4 is the new profit sharing ratio of Raju, Rao and Ram. Raju, Rao and Ram.